you have the bookmarks?
No. Wait.
All right. Well, thank you everyone, and welcome to the finals and of course the closing ceremony of the Hague Inter-University Law Debate Tournament of 2026. It's been a pleasure having you all participate and observe and support the teams, and of course to our honorable judges to provide your expertise and support for the teams throughout the competition so far. It's been a pleasurable 9th edition. It's a pleasure to also welcome the two teams that have taken the journey and are able to join us from The Hague. So today we'll be having a hybrid final with the match for the 3rd place happening 50-50 virtually and in person. So in a short moment for the... Yes. If you remember, the WebEx hiccups, they do happen also in finals. All right, so today is the final day of the Hague Inter-University Law Debate Tournament. It's been intense, a few months of debates, several rounds. This year's edition was held in the spirit of the crossroads of conflict and cooperation in international law. It has been reflected throughout the debates from first day of the group phase all the way to today's final. Just a short commemoration, this year we have welcomed teams from over 20 countries. 32 teams in particular have joined the 9th edition. Just a few of them on the screens behind me. The progression of the finals has been intense, so to say. There have been 3 rounds in the group phase for the debates where the teams were allocated in their groups and were progressing throughout the debates all the way to the elimination stage, which started in April. From the April debates, we have gotten here today with the 4 teams. Most of you already know, but I'll go back for it. The 4 teams that have qualified for the finals, of course, for the match of the 3rd place, the University of Nairobi joining us online, and of course the University of Alma Mater Bologna joining us in person. For the match for the 1st place, it is the Jigme Sigme Wonchuk School of Law joining us online from Bhutan, and Auckland University of Technology joining us in person from The Hague. The other of the 32 teams have done remarkably well. Several of the rounds, as organizers, we had to observe were quite a close call. I see several judges nodding, so it might have been also the case for you when you have seen them. So all the way behind me, this is the ranking of this year's edition. So really a particular shout out for all the teams and the work they have done throughout their debates. The World League of Legal Debates of The Hague debate style is quite intense. We have started in 2015, the first time in The Hague. Since then, I would say the family and the network of CORAX has grown intensely. The results from 2018 are quite clear. We started with the Domhelde and Hague match being one of the first international matches that we had. Today, in the 9th edition, there has been a considerable progress. Ranking from the 24 to 2025 are behind me. The rankings for the 2026 edition will be updated after these finals, and they'll be shared through our social media, of course, with everyone. It would be amiss not to recognize the work that the student associations have done throughout the editions. In this edition particularly, we had the pleasure and delight working with several of them, and this year is not unique. The student organizations, together with professors, have been working intensely with selection of the students, with their guidance, with their support, from preparing workshops, from helping select the teams, to all the way to today, supporting their journey and announcing their progress and sharing their support throughout. So thank you, everyone. For this year, we have the match wins record behind me. I'm not going to repeat it. Everyone in the room already knows most of it. But for those of you online, you can see it has been quite a journey for all the teams. today. Right. So what would be today's final about? It is accountability without borders. It is quite, I would say, a topical theme when it comes to today, because at the heart of international law, it is cooperation. It is the accountability, it is the support, and it is open dialogue. And the students today, and students throughout this year's edition and previous year's editions as well, have engaged with that intensely. You have opened your minds for research. You have opened your hearts for engagement with the other students. You wouldn't be here if you didn't wish to engage with anyone else. You wouldn't be here if you didn't wish to grow as professionals. And honestly, it's been an honor to watch you and to support you and to be able to do that for the next steps to come. Before we go to the first match, the match for the third place, I would kindly ask our judges for short introductions. I will be turning the camera towards you. We will be turning the camera towards you. So, just a few minutes.
Should I start? Thank you very much. A pleasure to be here again. My name is David Den Dunne. I'm a lecturer of law here at the Hague University of Applied Sciences, teaching international law, legal skills, and it's a pleasure and a privilege to be again serving on the jury of this debate tournament. I look forward to the competition.
Thank you.
Thank you.
Hi, I'm Dee Dee Johnson, and I am an independent environmental and legal consultant. And I'm really excited to be here once again, and I look forward to hearing all of you debate in this very interesting debate today.
Thank you.
Hey, I'm Matheus Mendonça. I'm from Brazil. I'm an international lawyer, and it's really great to be back here this time as a judge, but I was in their place. I'm a former participant, and it's really great to see how the competition has grown, and I'm really excited for today's match.
Thank you.
Hello, my name is Michaela. I'm a lawyer and a lecturer in law and technology here at the Hague University, and I'm very excited for you today. Best of luck.
Thank you.
Hey, I'm Karim Ablaz. I'm an assistant professor of public law at the United Arab Emirates University, and it's my pleasure to be here with you with this amazing debate competition. Thank you.
Thank you.
Thank you very much. So the match for the third place between the University of Nairobi and University of Alma Mater Bologna will be discussing whether or not states controlling the headwaters of international rivers must give priority to preventing significant downstream environmental harm over domestic economic development. So, as always, 4 positions for each team. And for today's debate, it will be the University of Bologna that will defend the in favor position, and the University of Nairobi will defend the against position. So, repeating, the debate for today will be on the subject: states controlling the headwaters of international rivers must give priority to preventing significant downstream environmental harm over domestic economic development. You have 5 minutes. Thank you very much. And the best. All right, thank you very much. Just a brief admin check before we start. I will be asking just the two teams to introduce themselves, and then we'll start the timer for the first speeches, starting with the team in favor. So just to confirm, since we are on the screens, I just remove the visuals. All right, so I would first ask the Nairobi team if we can just do the introductions, please. With the team introduction, so you introduce the team members.
Good afternoon. I hope you can hear us.
Yes.
My name is Ian Irungu from the University of Nairobi Faculty of Law. I'm very happy to have proceeded to this stage of competition, and I am looking forward to engaging with you on debate today. I shall leave the floor to my colleagues to introduce themselves.
Thank you. Next team member, please introduce yourself.
Right. Hi, everyone. My name is Paul Kitui from the University of Nairobi. I'm also glad and I feel privileged to have made it this far into the competition, and I'm looking forward to a great match. Thank you.
Thank you.
Great, just confirming if you can hear me and see me. My name is Miss Jane Baraza, and I am also from the Faculty of Law, University of Nairobi, and I'm really glad to be here for the third place match. It's been an honor competing against all other esteemed universities, and I'm just looking forward to the match against the University of Bologna today. So yeah, thank you.
Thank you very much. Now I will ask the University of Bologna for the team introductions. And the last one of you, I will also ask to give us the start when you're ready to open the speech.
So I am, good afternoon for everyone. My name is Maria Vitória Soldatelli. I'm from Brazil. And
Maria, is that your name? Maria?
Maria Vitória. I'm Brazilian, where I'm a lawyer. I'm currently doing my master's degree in legal studies in the University of Bologna, where I'm also a managing editor for the Bologna Law Review. And I'm here representing my team for the introductory remarks. Thank you very much. I wish everyone a pleasant match.
Good afternoon, honorable judges, and good afternoon to my opposition. My name is Alessandro Marsh, and I'm from South Africa, but currently I'm pursuing a master's in legal studies with my colleagues at the University of Bologna. I'm very honored to be here in person, and I'm very honored to make the acquaintance of the opposition and the esteemed judges. Thank you.
Hello everyone, I'm Ceren Özcan. I'm from Turkey. I'm currently doing my master's in University of Bologna in legal studies. And before I was practicing as a lawyer back in Turkey, in my country. And I wish a great match to all. Thank you so much.
Could you repeat your first name, please?
Ceren.
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 Thank you.
It's a pleasure.
Thank you very much. As both matches are 50-50, just a short information that the timekeeping information will be given through the camera that you can see in the middle. So both the person in the room can see it as well as the person online. Right. So without further ado, I give the floor to University of Bologna.
Okay. Well, honorable judges, I stand before you to defend the motion. Imagine a state on the path of development, but it depends on an international river. It does not control at its beginning, at its source. Now imagine the upstream state invokes sovereignty over that river while using it in a way that contaminates the water course before it reaches the downstream state. Well, the downstream state did not create the harm, but it's affected regardless. And here I ask, is a community of states truly fair if one state's development poisons the conditions of another's? We believe that it's not. Our position rests on 3 points. First, international watercourse law makes prevention a condition for the lawful use. Second, prevention must become before harm, because it's usually environmental harm, it's usually irreversible. And third, prioritizing prevention does not prohibit development, it makes development legally sustainable. Regarding my first argument, headwater states have a physical advantage because they control the river before the downstream states can protect themselves. And this is why, while Article 5 of the UN Watercourse Convention of 1997 states that states have a right to a reasonable and equitable utilization of water, it also requires this use to be optimal and sustainable and consistent with adequate protection of the watercourse. Article 7 then requires that states take all appropriate measures to prevent significant harm to other watercourse states. This is why Article 10 establishes that no single use of that watercourse has inherent priority over the other. And that conflict, when it happens, must be solved with special regards to vital human needs, referencing the principles from Articles 5 to 7. And here I must ask, which vital human needs will be met if a river is destroyed before it even reaches a state where the people live in? Second, priority is necessary because environmental harm, it's usually not reversible after damage is done. And the ICJ confirmed this in the Costa Rica versus Nicaragua case, where Costa Rica built a road alongside the San Juan River and without making an environmental impact assessment first. But, well, where there's a risk of significant transboundary harm, a state must ascertain that risk before the activity, which is why the ICJ decided that Costa Rica violated that obligation, because the assessment came too late. And this was the same logic in pulp mills. The ICJ held that environmental impact assessment is required under general international law when their activity risks a significant transboundary harm, especially when a shared resource. And as we've seen in Gabchikova-Nagimaros, vigilance and protection is required because environmental damage is often irreversible and reparation is limited. And this brings me to my final argument. Prioritizing prevention does not reject development. It protects the only form of development that international law actually recognizes, sustainable development. And this is reflected in Principle 4 of the Rio Declaration of 1992. Environmental protection is an integral part of development and cannot be considered in isolation from it. And this is why prioritizing prevention also prevents the state from externalizing its environmental cost of its development to another state. For instance, take the Kishinganga arbitration on hydroelectric project in India was allowed, but only if India did allow at least a minimum downstream flow to the downstream countries. And here, development was conditioned to the environmental duties, not stopped by it. And this is what we defend. To conclude, oh, sorry, I finished my speech. Thank you so much.
Thank you very much. For the opening statement in the against position, University of Nairobi, you have 4 minutes.
Good morning, good afternoon, panel and proposition colleagues. Just to confirm that I am audible before I begin.
Yes, you are.
Thank you very much. My time starts now. Now, members of the panel, the proposition's vision is a world where the no harm principle categorically overrides equitable utilization whenever the two principles conflict. However, the opposition's case rests on a single animating principle that international water law calls for an equitable balancing of all legitimate interests. This is not a hierarchy that privileges downstream environmental concerns over upstream development rights. Members of the panel, the proposition has affronted the UN Convention on the Law on the Non-Navigational Use of International Water Courses from 1997 as the basis for proposing that there is an international law obligation on upstream states to prevent downstream excessive environmental harm, even if it conflicts with domestic economic development. However, let us take a look at the UN Water Courses Convention. We see that while Article 7 imposes an obligation on the states to prevent significant environmental harm to other watercourse states, this is itself qualified and subject to Article 5, which states that the overriding principle is equitable and reasonable utilization. Now, Article 6 of the Convention then goes on to give the factors that should be considered when determining whether there is equitable and reasonable utilization. Notably, Article 6.2b states that the economic needs of the watercourse state is a relevant and valid factor to be taken into consideration when considering equitable and reasonable utilization. In fact, Article 6.3 then goes on to say that all of the factors in question need to be considered holistically. This means that even subject to the UN Water Courses Convention, there is no definite hierarchy that prioritizes prevention of significant environmental harm over the domestic economic development of the watercourse state. In fact, members of the panel, even the ILC draft articles on the UN Water Courses Convention prepared 3 years earlier in 1994 explicitly state that there can be a situation where there is significant environmental harm caused, but that is in line with equitable and reasonable utilization. This means that what is required under international law is a balancing of the principles at hand and not a veto power by downstream states taking into consideration environmental harm over the domestic economic development needs of the upstream state. Again, the proposition invokes cases such as pulp mills, Costa Rica versus Nicaragua, and Gapchigovo-Nagimaros. Members of the panel, in pulp mills, the ICJ definitively found that there was no substantive violation of the duty not to cause excessive transboundary harm. They simply found that Uruguay had not complied with the notification requirement and the environmental impact assessment. The same thing happened in Gapchigovo-Nagimaros. One of the countries, this is Hungary, halted the development of the Danube River on the premise that there were environmental concerns. However, the ICJ still held that Hungary had again breached its obligations. This is because it said that there is no absolute rule that environmental concerns will take precedence over the economic development of a state. The states have to cooperate and perform the weighing and balancing tests to determine whether the risk of significant environmental harm outweighs the need for domestic economic development, members of the panel. This is because even in environmental law, there is the principle of common but differentiated responsibility. This means that while all states bear the responsibility to protect and preserve the environment, there's a differentiated responsibility of different states owing to the levels of economic development. If this principle is present in international environmental law, why then should it not apply to the law on international waterworks, given that we understand that different states are at different levels of economic development and therefore have different developmental needs? It would therefore be unfair and prejudicial to impose upon upstream states that are still developing countries the obligation not to consider their own economic development in the interest of developed downstream states that have already taken up decades of historic rights in terms of exploiting these international watercourses. Therefore, members of the panel, this is the opening from the opposition. Thank you.
Thank you very much. We'll now proceed to hear the rebuttals, starting with the first rebuttal by the team in favor, University of Bologna. You have 2 minutes.
Honorable judges, we completely agree with the opposition when they say, when we talk about prioritization, we're talking about what we do when one of these interests come into conflict with the other. Now, the opposition says we need to call for some kind of balancing act. They say that there is no strict hierarchy in the Watercourses Convention. But I'd like to take a look at those two articles, Article 5 and 7. And we can see something there. We can see that Article 7 provides for this no significant harm rule. It has an explicit restraint on economic activity should that standard be met. And yet, when we look at the environmental protection considerations, we see that there is no similar restraint placed on them. And this shows that this is not an equal consideration. One provides a firm backstop and the other does not. And there's a reason for this. There's a reason why international law has always held for these kinds of principles. If we look at the Trans-Malta case, which had to do with Canada polluting cross-border neighbors, we saw there that the court held without a shadow of a doubt that you cannot conduct such economic activities when they harm another state. Okay. And so what we're talking about here is what we are opting to risk. are we opting to risk economic development, or are we opting to risk environmental protection? This is what the prioritization means. And time again, the treaties and the courts have said that when they come into conflict, the economic activity cannot proceed should there be a significant harm. Now, it may not look like an outright hierarchy, but what it's saying there is that we've established a real standard there, a standard that cannot be broken, a standard that cannot be defeated, and a standard that's been held in international law for a while. And so this risk choice for us, presents this kind of prioritization, despite there not being a listed hierarchy in the convention. Thank you.
Thank you very much. Now for the rebuttal from the opposing side, University of Nairobi, 2 minutes.
Just to confirm if I am audible.
Yes.
Thank you. I'll begin in my next part. Panel, the opposition do not dispute that states might undergo significant harm. In fact, even the UN Watercourse Convention agrees to that under Article 7.2. But in its wording in itself, it says that where significant harm has occurred, the harming states might engage in compensation and negotiating other reparation mechanisms with due regard to Article 5 and 6 of the UN Watercourse Convention, which clearly front the principle on equal and reasonable utilization of resources. But most importantly, the proposition team has stuck their arguments while referring to the shale smelter arbitration case. However, as fronted by first opposition speaker, the UN Watercourse Convention in itself is a lex specialis case, especially it has lex specialis convention law whenever it comes to like Watercourse Convention. That is what is important here. With regards to the case that has been fronted by the proposition team, the shale smelter arbitration is part of lex generalis. It appears to like general environmental law, so that is not as sufficient within this particular instance. But most importantly, would like to also front the International Law Commission 1994 report, which was fronted to the UN General Assembly, where in that particular report they actually acknowledge that in certain circumstances, equitable and reasonable utilization of international resources may still cause significant harm. But generally, in such circumstances, the principle of equitable and reasonable utilization remains a guiding factor in balancing the interests of all states. And this was clearly reflected in the late Lano arbitration case, where the tribunal was able to acknowledge that there's already a growing, nature of conflicting of interest whenever it comes to nations. And the only way to resolve these issues is when you're able to have a balance of all interests. And this only adheres to the theory of the limited territorial sovereignty theory. If you agree with the case that has been fronted by the proposition team, you're actively taking the absolute territorial integrity theory, which actively gives veto power towards downstream states, which essentially creates it creates a reverse harm towards upstream states which do not essentially concern. Thank you.
Thank you very much. For the second rebuttal, team in favor, 2 minutes.
Honorable judges, for this last part of my rebuttal, I'd like to start off by mentioning two numbers. The first number is 60 million, and the second number is 5. The first number represents the number of dollars made by companies like Shell and others operating in Nigeria, for instance. And the second number represents the average daily wage of someone from Ogoniland in Nigeria. Now, previously, the opposition mentioned just how vital it is to promote this economic domestic development. But I'd like to know who exactly is benefiting from this development. Is it Shell in Nigeria? Is it Chevron in Angola? Why is the inequality still so apparent in where the money goes? And so we need to look carefully there, because the law needs to protect those who can't protect themselves. The villages there and the local people there need the backstop of the law. They need that prioritization. The corporations will do just fine. Furthermore, there is a maxim in the law which is ubi jus ibi remedium, which means that where there is a right, there is a remedy. And now this maxim has worked for millennia, but we need to start reanalyzing these things, all right? Because scientists have told us that when these rivers dry up, these deltas don't rise again. They're gone. Scientists predicted that fisheries in Canada, in Scandinavia would come back back to normal after 5 to 9 years. These changes turned out to be permanent. So I'd like to ask the opposition a very key question here. If we don't prioritize environmental protection, what would the effective way to bring those resources back be when they're gone? When they're gone, there's no getting them back. Economic development will always be there, but the economy needs an environment in which to thrive. As Herman Daly said, the economy is a subsystem of the environment. Without the environment, we have no economy. Once that's gone, it's gone for good, and it hinders economic development as well as that. Thank you, honorable judges.
Thank you very much. Second rebuttal from the opposition, 2 minutes.
Can I do concluding?
It's fine. So that's all. Like to confirm that I'm audible and visible.
Yes, you are.
Thank you so much. Okay. My speech starts on my next word. We appreciate the very vivid picture that has been painted on what this means on a very palpable level for people. Therefore, we'll also engage on that premise. But before the numbers comparison, our position is that there should be no definitive hierarchy, that one state should not matter over the other, but that general means should be considered. And despite the consistent argument the prioritization of environmental development. We've consistently shown across lex specialis law as well as general case law that make up customary international law that a balance should be incorporated. And a balance means the well-being of the people, which then complements, the environmental factors and remedies that are there, even in the case where breaches are found to have been there, like environmental harm, there is a mitigating case, and the lex specialis law also provides for this. Look at the case of India and Pakistan, for instance. India has 700 million poor people who would otherwise benefit from the provision of the water sources for the use of electricity. The people of Pakistan complain in the Shenganga project that they may lack water if India utilizes this water for electricity. But the needs should be balanced with both, because in as much as the people of Pakistan may want to dry the channels, may complain of the possibility of drying channels, it is also incumbent for us to care about the people of India and their felt needs in that regard. So 700 million people is a significant amount of people. Same case happened in the Great Blue Nile, where you have Ethiopia as the source as well as Egypt. The people of Egypt as well have their felt needs, and while they may be valid, it is also an obligation for the people of Ethiopia to cater to the needs of their people, and therefore reinforcing the same principle that we have highlighted has been made legitimate by law that is specific to this instance as well as customary international law. Thank you.
Thank you very much. For the concluding statement for the in favor position, University of Bologna.
Honorable judges and esteemed colleagues, as we step back and look at the entire landscape of this debate, it becomes clear that there is a single and very important conflict. How do we define a lawful and sustainable right to develop? As my colleagues have demonstrated, the answer is definitive. The economy is ultimately a wholly owned subsidiary of the environment. The opposition has built their case on the idea of a symmetrical balance, arguing that Article 5 puts economic needs and environmental protection on the same level. We understand why this framework sounds practical, but it ignores a fundamental fact. Balance does not mean symmetry. When we look at the actual architecture of the UN Convention, Article 7 places a strict, explicit limit on economic pursuits by demanding that states prevent significant harm. Crucially, the law places no such restraint on environmental protection. This is not a coincidence. or this is not a mistake on drafting, it's a logical necessity. As the trial smelter arbitration established, no state has the right to use its own territory against another. The law allows for progress, but never of the price of harming the ecology. From legal text to jurisprudence and down to basic economic reality, the conclusion is undeniable. Factories, farms, and human societies cannot function without a great environment. So the economy depends on the environment, but the environment does not depend on the economy. We do not ask to dry up the river of progress. We simply ensure it has a future to flow into. For these reasons, the motion must stand. Thank you so much.
Thank you very much. For concluding statements, University of Nairobi, 2 minutes.
Just confirming if I'm audible again before I proceed.
You are okay.
Great. Starting my speech in 3, 2, 1. Honorable panel, the proposition's case rests on the need for economic development for downstream states and the need to prevent significant harm. And the opposition team does not dispute that. In fact, all the cases that we have cited before you are in agreement with that. However, every case that has been cited by team proposition, be it the Trail Smelter arbitration case, be it the Gachikovo-Nagimaros case, be it the pulp mills case, they acknowledge both stances. And that is what equitable and reasonable utilization of resources can assure you. Because even if they put the entire argument to rely on Article 7, that is only Article 7.1. Article 7.2 clearly still takes them back to have due regard to Article 5 and 6, which clearly stipulate on the equitable and reasonable utilization. And that was similarly upheld in the recent case of Silala between Bolivia and Chile, where the ICJ was able to still uphold the fact that equitable and reasonable utilization is the upholding or like the guiding principle, especially when it comes to shared water courses. Similarly, within the next specialist case. But even when it comes to defining what equitable utilization and equitable and reasonable utilization looks like, it means like achieving fair and just balance of interest of all states that are sharing a water course. It involves inclusive participation while assessing the quantity of usage. So what this means is that Ethiopia, which is an energy deprived state, and also Laos and Nepal, these are states whose acute development needs need to be taken into account. They should not be required to permanently subordinate their interest in being able to uphold a principle that actively vetoes their downstream powers in being able to essentially bar the developmental needs of upstream states. If that happens, the proposition team are bound to defend a situation where upstream states are actually bound by the reverse effects of not being able to develop. It creates a two-way level of harm. We do not defend a two-way level of harm, we defend balance. And that is what developmental needs and equitable, reasonable and utilization defends. Thank you, that's team opposition.
Thank you very much. This marks the end of your debate for the third place. Well done to your team. We'll now enter a short break for the judges to take their time to review your matches as well. Afterwards, we will be coming back with the debate for the grand final. I just want to really acknowledge the journey that your teams have taken over the course of these past months. For the University of Nairobi, you have had quite intense debates in your group phase. You are in a group H. You have met the debaters of the Prince Sultan University, of the ILM University of Milan, University of Maryland in your group. In your 8 finals, you have met University of Malta. In quarterfinals, you have met, of course, JSW School of Law. So you've had quite a journey. For Bologna team, you were in Group A. I don't want to spoil, but Group A also has another team that made it all the way to the final day. You have met Tallinn University of Technology. You have met JSW School of Law. You have met OP Jindal Global University in your group phase. You have also met University of South Pacific, Melbourne University, and Auckland University of Technology. So really, I think you have the reasons to be proud for yourselves. You have done a tremendous job of representing your universities. So we go to a break. Right. Well, thank you, everyone. We are back from the break. In a short moment, we will have the opportunity to see and witness the debate of the grand final between the teams of Jigme Sigma Wonchuk School of Law and the Auckland University of Technology. Of course, this match as well, the previous one will be in a hybrid format, so we have one team in person, one team that will be joining virtually. Before we get to that part, I also want to use the moment to acknowledge the support that we have received over the years from our partners, particularly the Oxford University Press that has been with us since the very beginning. So we have started with the support for the international law collections that they have made accessible to the students from the first year. And this year is the second year they have shared their whole law trove for the participating students, which I assume and I hope I have seen the results of during the debates over the past few months. So really, thank you to our partners for being with us from the very beginning. It's been an honor to share the resources that you have made available to the students. Of course, to the KLM and the Air France, we thank you for the support that you have given us for the travel opportunities for the students that are arriving for the final week, as well for any judges and jury members that have traveled as well to make the way. Thank you for that. And for the students, you have heard me speak before over the months, more on the timekeeping and introductions, but I just really want to say that it's been a pleasure to see you grow as global citizens, because being able to look at a topic and evaluate it from two sides, not just the one that inherently comes to you, maybe through your studies or your experiences, but being able to look into any situation and acknowledge respectfully that there is perhaps a different version, different facts that you might take into consideration, and respectfully engage in a dialogue with the other party is not only a skill of a good lawyer, it's a skill of a global citizen. And it is an important skill to take into the years that come ahead. My apologies, I have been going in the wrong direction. So, for the presentation of the jury for the grand final, if we can start, perhaps.
Okay. Hello everyone, good afternoon and welcome to the grand final. My name is Dr. Maria Eva Földes. I'm working as a researcher and lecturer, assistant professor at Erasmus University Rotterdam. But before, I was a member of the TUAS family here. I've been a lecturer here in international and European law, and it's really my pleasure to be back and to act as a judge at the final.
Thank you.
Good afternoon, everybody. My name is Altamash Khalil. Welcome to the finale of this edition of the Hague Debate Tournament. I am currently a lecturer here at the Hague University of Applied Sciences, and previously, I think 4 years ago was it, I participated in the Hague Debate Tournament, and fortunately, our team was the winner. I've been coaching the competition and particularly the Hague University of Applied Sciences in this competition, and I'm very happy to be here amongst all of you, and good luck to both the teams.
Thank you, David and Dunne, lecturer of law here at the Hague University. Happy to be back again, and good to be here at the finale, at the final round, and wishing both parties best of luck.
Hi, Didi Johnson. I'm from St. Martin. I'm an independent environmental and legal consultant. And I'm really excited to be here at the final debates. I was here last year and I'm here today, and I'm really excited to hear both teams, and I wish you guys the best of luck.
Hi, I'm Matheus Mendonça. I'm a former participant, part of the Brazilian team, and also I'm a lawyer, an international lawyer in Brazil. It's great to be back in here, and I wish the best luck to both teams.
Hello, my name is Michaela. I am a lawyer and lecturer at the Hague University, and I would like to wish you the best of luck.
Hello, I'm Karim Ablaz. I'm assistant professor of public law at the United Arab Emirates University, and I'm wishing you all the best.
Thank you very much. All right. So for the grand final of the 9th edition, the teams will be debating on whether or not foreign states should retain sovereign immunity from civil claims arising from serious cross-border cybercrime operations or cyber operations attributable to them. Before we, of course, hear the opening statements and also find out which team will defend which side of the debate, I will be asking the students to present themselves.
Yes.
So we will be starting with the Jigme Sigme Wangchuk School of Law, joining us from Bhutan.
So you have the floor in Bhutan.
So, hello everybody, I am Yudin Dema and I am currently a third year law student here at the Jimsonju School of Law, and I look forward to a very great match ahead.
Yes, and your colleague?
Hello, my name is Sonam Hadin, and I am also a third year law student at the JSW School of Law. And I wish the very best of luck to our opponent and look forward to a great match as well. Thank you.
Thank you. And third member?
Hello everyone, my name is Kila Yangdon and I'm a second year law student here at JSW School of Law, and I also look forward to a wonderful match. Thank you.
Thank you. We'll now ask the Auckland University of Technology for the introductions.
Goedenavond. Tēnā koutou katoa. E nā kai whakawā, e nā kai whakahite o te CoreX Foundation, e nā māngai kāwanatanga, e nā kaiako, e nā tauira, e nā manuhiri me te hunga e mātakitaki mai ana i te ipurangi, o tira o mātou whānau hoa, me nā kai tautoko e mātakitaki mai ana i Aotearoa. Tēnā koutou, tēnā tātou katoa, ko Tremaine Thompson ahau, no Aotearoa ahau, no Ngāpuhi no te Aupori, no te Ngāti Hine, no te whakatōhia huki. He tauira ture tau tuarua ahau i te wānanga o Aotearoa, te wānanga arunui o Tāmaki Makaurau. Kia ora koutou katoa. Greetings to you all. That is Te Rero Māori, which is the indigenous language of New Zealand. Translation. This is an English-speaking competition, so I should give you a translation. Greetings first to the judges, to the organisers of CoreX Foundation, diplomatic representatives, coaches, students, distinguished guests, and those joining us online, particularly our very large cohort of supporters in New Zealand at what is now about 2 o'clock in the morning. Our families, our friends, all of our supporters watching from New Zealand, greetings to you all. My name is Tremaine Thompson. I'm a second year Bachelor of Law student at the Auckland University of Technology. I'm really looking forward to this match. I wish our friends in Bhutan the best of luck. Thank you.
I can't do much better than that, but my name is Jazz. I'm a second year law student studying a Bachelor of Laws at Auckland University of Technology. Really looking forward to the match, of course, and all the best to the opposing team.
Thank you very much. I can confirm that we are eager to learn more about the topic through your debate. As always, there are 4 possibilities, 2 for each team. And it will be the Auckland University of Technology defending the against position during this debate. Thus, we will be starting with the team of Jigme Sigme Wangchuk School of Law. We will now have 5 minutes to finalize the preparations, and the team in favor will start. Thank you, everyone. We have now finished the time for preparations. We'll start by hearing the opening statements for the in favor position. JSUW School of Law, you have 4 minutes.
Before I begin, may I please clarify a doubt? Thank you very much. So, who will be the one doing the timekeeping, and where can we see it?
Of course. So the timekeeping will be done through our student organizer. So you will see the yellow card when 30 seconds are up, and the red card when your speaking time is over. Of course, comfortably conclude your sentences.
Thank you very much for clearing my doubt. Then I shall begin. I shall begin my opening statement in 3, 2, and 1. Esteemed judges and respected opponents, in 2012, the ICJ confirmed that Germany retained immunity even against alleged violations of international law. This showcased the utmost importance that sovereign immunity holds towards preserving sovereign equality and uninterrupted public administration for almost 193 states worldwide. And as such, we uphold the motion that cyber operations should retain immunity from civil claims arising in foreign with 3 points. First, no cyber exceptions. Second, attribution. And third, remedies for claims. First, there is no law or principle that says that when applying immunity, cyber operations are suddenly an exception. The 2004 UN Convention on Jurisdictional Immunities for States and Their Property upholds the principle of par in parem non habet imperium, which says that equal states like you and me shall not have jurisdiction over each other. And in the cyber context, we have legislation from the US, the UK, and Canada, which do not mention any exception for cyber operations when applying immunity. And moreover, you must understand that your act is stripped of immunity only when it is an acta iure gestionis, an act of a private or commercial nature. And in this regard, the cyber operation becomes a state activity. In the case of Jones versus Ministry of Interior in Saudi Arabia, the court refused to strip immunity, understanding the importance that structural immunity is demanded by sovereign equality. Now, second, since we are talking about civil claims, let's talk about how we can attribute them correctly. RCW Articles 4 to 11 say that conduct can be attributed to a state only when, firstly, it was done by the state's organs, secondly, private individuals were acting under the state's orders, or the states are like, yes, we did it. But that is notoriously difficult in cyber operations. You see, NotPetya was linked back to Russia's sandworm unit only after months of investigation, and the Sony Pictures attack was linked to North Korea only due to undisclosed FBI intelligence that the public never knew fully about. So if these highly equipped state-level agencies are finding it difficult to exactly pinpoint who did it, then how are you so sure that these domestic courts would be able to do it accurately and especially without political bias? Now, third, we must remember that there are already claims available under international law. Articles 30 and 31 of the RCW stop the wrongful conduct of states and make them pay full reparations. And additionally, Articles 49 to 54 of RCW allow injured states to take proportionate countermeasures. And we also have the NATO's 2021 Brussels Summit Declaration, which said that if you use your cyber weapons on us, then you can invoke collective defense response from our states as well. And these must be acknowledged. The proposition must now prove that these remedies are substantially ineffective and that attribution can be done accurately by these foreign courts. Otherwise, we will be supporting a regime that upholds wrongful attribution, that does attribution based on doubt, and which will end up only burdening smaller states with a landslide of cases that are mostly unnecessary or maybe even insignificant in nature. And as a result, we have to uphold this motion. So judges, rule for this motion once again. I conclude my opening here. Thank you.
Thank you very much. for the opening statement in the against position, Auckland University of Technology. Floor is yours.
Your Excellencies, honourable judges, distinguished guests, and my learned friends. International law has never remained static. It evolves when new realities expose the limits of existing rules. Sovereign immunity itself is an example. What was once an absolute doctrine developed exceptions as international law recognized that accountability sometimes matters more than immunity. Serious cross-border cyber operations present the very next challenge. My learned friends asked this jury to preserve immunity. We asked this jury to preserve accountability. Our case rests on three propositions. Firstly, sovereign immunity has never been absolute. Secondly, international law should respond to consequences, not to methods. And thirdly, serious cyber operations create accountability gaps that immunity cannot justify. My learned friends present sovereign immunity as a fixed and untouchable doctrine. International law, however, tells a different story. Over time, sovereign immunity has yielded where competing legal interests become sufficiently important. Commercial activity exceptions emerged, employment exceptions emerged, territorial tort exceptions emerged. The United Nations Convention on Jurisdictional Immunities of States and Their Property, which my learned friends rely on, actually reflects this reality. The history of sovereign immunity is not the history of permanence. It is the history of exceptions. That does not mean immunity is unimportant. It means immunity is not untouchable. Honourable judges, the question before you today is whether serious cross-border cyber operations represent the next circumstance in which accountability should prevail, and we submit that they do. My learned friends will focus on the digital nature of cyber operations. Respectfully, that focuses on the wrong issue. International law should focus on consequences. A hospital deprived of critical systems suffers the same harm regardless of whether the cause was a missile or a malicious code. A power grid disabled through cyber means can disrupt lives just as effectively as a conventional attack. The victims do not experience digital harm, they experience real harm, and the legal response should not depend upon the method used to inflict it. If international law recognizes the seriousness of physical harm, then it must be capable of recognizing equivalent harm in the cyberspace. My learned friends argue that accountability remains available through interstate mechanisms. But accountability for whom? States may pursue responsibility. States may seek reparations. States may engage in diplomacy, but the victims cannot. The hospital administrator who's been affected by a cyber operation cannot compel diplomatic negotiations. The small business owner suffering catastrophic losses cannot initiate interstate proceedings. The family affected by disrupted critical services simply cannot demand that governments promote or pursue their claim. They are left dependent upon political decisions over which they have no control. That is not meaningful accountability. That is an accountability gap. My learned friends rely heavily on Germany v. Italy, and we accept that authority. But Germany and Italy tells us what international law was. This debate concerns what international law should be when confronted by forms of harm that challenge traditional assumptions about sovereignty, territory, and responsibility. Honourable judges, this case concerns whether international law should remain capable of responding to new realities. The law of sovereign immunity has evolved before, and it can evolve again. For those reasons, we ask you to reject the motion. Thank you.
Thank you. We'll now proceed to hear the rebuttals, starting with the team in favor. For the first rebuttal, you have 2 minutes.
I shall begin in 3, 2, 1. Honorable judges and esteemed opponents, 3 points for rebuttal. First, the opposition's argument rests on a fundamentally vague standard. There is no universally accepted definition of what constitutes a serious cyber operation in international law. Neither the UN Charter, the ICJ, nor state immunity conventions recognize seriousness as a legal threshold for stripping sovereign immunity. This creates legal uncertainty. Does serious mean economic loss, disruption of services, data theft, or physical harm? If the opposition cannot provide the precise and universally recognized legal threshold, their proposed exception collapses against reason. Second, the opposition mistakes both the law and the motion. The debate statement asks whether states should retain sovereign immunity, which presupposes that such immunity currently exists. The reliance on the territorial tort exceptions and sovereign immunity is misplaced because cross-border cyber operations are conducted from outside the victim's state territory, meaning the conduct itself falls beyond the scope of that exception. More importantly, removing sovereign immunity does not guarantee compensation. And lastly, the opposition relies on the severity of cyber harms and so-called consequences to justify removing sovereign immunity. Yet, they cannot identify any treaty, customary rule, or use Gogan's norms, creating a severity exception. Existing international mechanisms already address serious cyber misconduct, including the ICC's investigation of the 2024 Sandworm attacks. Even in the 2020 Dusseldorf ransomware case, a sufficient causal link could not be established between the cyber attack and the alleged death. Thank you.
For the first rebuttal in Deegan's position, Auckland University of Technology, 2 minutes.
My learned friends have stated that sovereign immunity applies given the procedural nature, full stop. That view does not, one, meaningfully address the core contention of today's debate, and that is whether sovereign immunity should apply. And two, it puts matters of procedure above real harm that is caused to victims. I'll give you an example, honourable panel. When Waikato Hospital in New Zealand was the victim of a cyber attack, patients' files were stolen, patients' financial records were stolen, oncology patients were forced to transfer, and surgeries were stopped. Honourable judges, I ask you to sit across one of these patients and tell them, sorry, the state that was responsible is immune from your civil claim. I ask everyone here today, is it fair to strip someone of their fundamental rights to justice? In the Germany-Italy case, Judge Concado at paragraph 179 stated that no state can invoke sovereignty to avoid the legal consequences by standing behind the shield of state immunity. There is no immunity for grave violations of human rights. And if there is, then that is unjust. Honourable judges, there is still time for change as the law develops. As Lady Fox puts it, the law of state immunity is not static. International law abandoned immunity, absolute immunity, when it became overreaching. The commercial activity exception emerged as states participated in markets. The territorial tort exception developed also. This shows that the law adapted when existing rules no longer affected reality, and in this case, it should too.
Thank you very much. For the second rebuttal for the in favor position, JSUW School of Law.
Then I shall begin my story rebuttal in 3, 2, and 1. Esteemed judges, before addressing the opposition's substantive arguments, we need to correct a fundamental misunderstanding of the motion itself. The debate concerns whether foreign states should retain sovereign immunity from civil claims, definitely not criminal claims. Throughout their argument, they are repeatedly invoking concepts such as criminal liability, war crimes, punishment, prosecution. But these issues are legally distinct and outside the scope of this debate. Civil claims concern compensation, damages, and the ability of private parties to sue a foreign state in domestic courts. They do not involve criminal guilt or imprisonment. And by conflating these two concepts together, the opposing team exaggerates both the harms and benefits of their position, but actually fails to engage with the actual question before the House. And secondly, unlike the opposition's assertion, we contend that cyber operations shouldn't become a new exception to sovereign immunity. The ICJ in Germany versus Italy confirmed that sovereign immunity protects state acts, even when the alleged conduct is believed to be serious or violates fundamental norms, because immunity is a procedural rule separate from the legality of the underlying act itself. Cyber operations conducted by military or intelligence organs are sovereign acts by nature and therefore fall outside existing immunity exceptions. Cyber operations are not recognized as a jus cogens category that would justify creating a new exception. Unless the opposition is able to prove that victims of cyber operations are a special category that deserve these standards, then we do not accept their points at all. We rest our rebuttal here. Thank you.
Thank you. For the second rebuttal in the against position, Auckland University of Technology. You have the floor.
Honourable judges, first point of rebuttal to their first rebuttal, they mentioned that territorial tort exception could not apply as the cyber activity that has occurred, it does not happen in the territory. This is false, and we point to the case of Bahrain in the UK Supreme Court of Appeal, where it was found that cyber operations are conducted in both states, so the one where the remote activity occurs and where the code is uploaded. So they are wrong on that point. The proposition has also severely relied on the Germany-Italy case. Honourable judges, that case should not be viewed alone, as there are other jurisprudence in the matter, and it should not determine the outcome here on three grounds. First, serious cross-border cyber operations are not ordinary sovereign acts. As the Ukrainian Supreme Court recently recognized amidst the Russian conflict, a state cannot invoke sovereignty to shield conduct that fundamentally violates the sovereignty of another state. So when a foreign state conducts serious cyber operations that disable infrastructure, for example, it is not exercising a sovereign right, and instead it is committing a direct intrusion into the sovereign domain of the other state. Secondly, the Ukrainian Supreme Court stated that sovereign immunity exists to promote comity and good relations between the states. But where a state has launched a serious cyber operation, this has already been severely undermined. You cannot then justify denying victims access to a court in the name of good relations and comity when it has already been broken. These same approaches were found in the 2004 case of Fereni in Italy and 2008 in Melda. Third, Germany and Italy arose in a context where Germany had already participated in reparation arrangements, whereas this is not the case currently with cyber operations. Thank you.
Thank you. We'll now hear the concluding remarks, starting with the JSW School of Law.
I shall begin the closing in 3, 2, 1. Honorable judges, behind every rule of international law lies a graveyard. Sovereign immunity was not drafted in peace. It was drafted in the ashes of 2 world wars. We understand the frustration of victims. We truly do. When hospitals are disrupted, democracies are targeted, and lives are affected, the desire for justice is completely understandable. But sympathy is not jurisdiction, right? In 2012, the ICJ held that Germany kept its immunity even for grave violations. Why? Because immunity is the structure holding peace between 193 sovereign equals. The 2004 UN Convention is clear. Par imperem non habet imperium. An equal has no authority over an equal. And Jones versus Saudi Arabia confirmed it. Even torture couldn't strip immunity because military cyber operations still are cyber operations, right? Are sovereign acts, right? And then there's the question the opposition keeps avoiding. Who did it? Under RCWA, Articles 4 to 11, attribution must be proven. Cases like NotPetya and Sony show that states are often identified as highly likely responsible. Should sovereign nations be condemned before the entire world on highly likely? Doesn't sound fair, right? See, the victims are not abandoned. Victims still have remedies. RCWA Articles 30 and 31 require full reparation. Articles 49 to 54 allow responses. And UN Charter Articles 33 to 36 provide negotiation and ICT processes. So no, immunity is not impunity. Honorable judges, on this ground, we respectfully ask you to uphold this motion because the wall of immunity was built after centuries of conflict. We should think a million times before we tear down even one brick. Thank you.
Thank you very much. For the concluding remarks for the against position, Auckland University of Technology.
Your Excellencies, honourable judges, distinguished guests, my learned friends. At the end of this debate, my learned friends ask you to choose immunity over accountability. We ask you to choose accountability without abandoning international law. 3 points remain unanswered. Firstly, my learned friends repeatedly rely upon sovereign immunity. But sovereign immunity was never intended to become a shield against serious harm, as highlighted by the 3 dissenting judges in the Germany v Italy case, especially Judge Concado at paragraph 179 of the court's judgment. The doctrine exists to promote comity and sovereign equality. It was not created to prevent victims from seeking justice when states cause catastrophic cross-border damage. Secondly, my learned friends insist accountability exists elsewhere, but throughout this debate they have pointed to remedies available to states. Our focus has remained on those who actually suffer the harm: the hospital, the small business, the family, the individual. For them, accountability dependent upon political discretion is not accountability at all. Thirdly, my learned friends ask you to believe that the digital nature of the attack changes the legal result. We say the opposite. International law should care less about the tool used and more about the harm caused, because a hospital deprived of critical systems suffers the same consequences regardless of whether the attack came from a missile or a malicious code. Honourable judges, ultimately this case is about whether international law remains capable of providing meaningful answers to modern harms. My learned friends ask you to preserve immunity. We ask you to preserve legitimacy. My learned friends ask you to preserve a rule. We ask you to preserve confidence that the rule remains capable of delivering justice. For those reasons, we ask you to reject the motion. Thank you.
Thank you very much. This concludes the grand final of the Hague Inter-University Law Debate Tournament of 2026. Thank you very much, and a big congratulations to the teams. Well done. And of course, as in the previous match, before we break for the break, I just again want to acknowledge the journey that you've had. For your teams, it has been quite a progression. For the JSW School of Law, dear students in Bhutan, joining us online from Bhutan, it's been a pleasure. During the group phases, you shared the Group A with the team of University of Bologna. You have faced against them in your group matches. You have also faced the Tallinn University of Technology, and you have faced the OP Jindal Global University. Afterwards, in the elimination stage, the second part of the tournament, you have met the University of Chile, and then you have met the students of the National and Capodistrian University of Athens. Before qualifying for the final, you have also had the match with the University of Nairobi's team. Well done. It's been an honor to see your progression. For the Auckland University of Technology, coming all the way from the New Zealand, Thank you for making the journey, of course, to The Hague. It's been a pleasure to welcome you and show you the city, and of course to all of you that are here. And we hope to also welcome our colleagues and friends that haven't been able, perhaps this edition. Maybe we see you in future as coaches. But for our details in New Zealand, you have faced the teams of McGill, of Tilburg, of University of Brighton in your Group C in the first months of the debates. Afterwards, you have seen the debate against University of Maryland with the Vienna University, and then finally you have matched off with University of Bologna. What a journey. What a journey, everyone. And with that, we break for the break. Thank you, everyone. We are back after the second break with the results soon incoming. For that side, before we announce the very exciting results of honestly very engaging debates today, I would be pleased to welcome the teams to share their wishes for the next edition. And of course, if you wish to send any message to your supporters, to your network that supported you, this would be the place to go. We'll be starting by the debaters of University of Nairobi. I'll be giving you the floor. You can pass the baton as you remember from the networking parts of the debates. So, of course, also feel free to send a message in your native language if you prefer to. The floor is yours, University of Nairobi.
Just confirming if I'm audible. Yeah, thank you. So my name is Ms. Baraza from the University of Nairobi. For me to just be to appreciate the organizing committee of this particular competition. This has been our first time participating. We've not been able to do it prior, and we have been able to learn a lot. Personally, I have meeting different people from the different universities, and obviously a shout out to one of our close friends, that is Sean from the University of Maryland. It was really nice connecting with the different universities. And for us is to just say, or personally for me, don't be scared to take up any opportunity, especially when it comes to such competitions. I think it's really nice for law school students. And yeah, in Kiswahili, we say asante sana. To me, thank you so much for the opportunity. Yeah, thank you.
Passing to your colleagues if they also wish to share some words for the next edition or this year's edition.
Just to add on to what my colleague said, essentially this has been a very fun journey in spite of all the trials throughout the experience in terms of timing, schedule, and everything. It's been a very nice and interesting way to interact with aspects of international law. And since this was our first time participating, I have to say we were a bit intimidated because we did not have any prior experience and we did not know exactly what the competition required of us. So my word of advice to prospective teams who are looking to participate in this competition is take the plunge because it's not as hard as you think it is. Obviously, it's not as easy as you hope for it to be. However, you're going to have fun nevertheless. And yeah, it's going to be an interesting ride either way. So yeah, that's all I have. Thank you.
Mr. Kitui?
Right. Yeah, sorry. Well, I'd like to thank my teammates, the Hague International University team, as well as everyone else for like everything they've done to make this possible. I think it's been a great experience. I'm grateful. Great learning curve as well. Yeah. Well, I'd like to shout out everyone else that we've met along the way. I'm sorry about that. It's like, yeah, so I'd like to thank everyone we've met along the way. We've met a lot of amazing people. We've interacted with people. So like Baraza has been able to shout out someone from like the Maryland team. I would like to shout out the entire team. I've gotten to interact with everyone at very extensive levels and I've learned from everyone, so it's been good. Lastly, my shout out is to everyone that's put themselves forward. It's not easy. It definitely requires a lot of work, and it's cliche, but showing up is half of the work, and I think that's very true even in this instance. Yeah, and I wish everyone a nice experience in their law school journeys or whatever it is they're doing, even after the competition. And thank you all.
Thank you very much. And I would also like to invite the University of Bologna team to come to the podium and to share their words for the next edition. Of course, if you wish to send a regards home.
Hello, everyone. Again, my name is. Sorry.
My apologies.
No problem. Hello, everyone. Again, my name is Jelen Ozcan from University of Bologna, and I would love to thank my teammates firstly because it was a great journey, and I can't imagine a team without them. And it was, as I said, a great experience. We had the chance to debate with many universities from all over the world. And thank you for the opportunity to the COREX Foundation.
Hi everyone. I just wanted to firstly give thanks to a shout out to my family for supporting me even from a long way away. A big thanks to my teammates. We shared a lot of key moments together, a lot of ups, a lot of downs. I'm very, very proud to be here with them today. I'd also like to thank our coaches, Jose Kulejan and Mahmoud, who's not here with us today. They're the best coaches a team could ask for. And of course, to the University of Bologna, and in particular to Professor Mauro Gatti for supporting us, for getting us here, and for being part of the journey we're so proud to have shared. And thanks to all our opponents and colleagues from other universities. It's been an honor to compete in the same competition as you.
Hello again, everyone. I'm Maria Victoria from University of Bologna, and I would first like to thank our coaches that are here with us and have been so helpful throughout the entire competition. We do hope that we made you proud of us, and also my colleagues, the COREX Foundation for always being available and so helpful to us, the University of Bologna as well, Professor Morgatti, and all of the judges for doing the effort to be here today. Thank you very much. This was an amazing competition, and I wish you a pleasant evening.
Thank you very much. Thank you. Now I would like to ask the JSW School of Law to take the floor.
I'll begin. So this competition has been a very enriching and illuminating experience for us. We definitely learned a lot, not only about ourselves, but about so many pressing issues and current states of the world. So many of the debate topics that we've had, we didn't really have an awareness on what they were prior to the matches. And so this competition has given us a lot to learn. Thank you. So regarding the advice that we want to give to the 2027 participants, first of all, I just want to say that you must first, I guess, believe in yourself that you can do it. Our team was a little bit unsure at first because we are the first team to ever participate in the competition representing our law school, so it was a bit of uncertainty at first, but along the way we met many amazing people. We learned more about ourselves and the potentials that we might have. Our team advisors were an amazing support, and as a result, I guess everything comes together well, so all is well. Thank you.
And in line with that, we have so much to be grateful towards so many. First of all, thank you to the organizers for providing us with this wonderful platform where it brought together so many universities from around the world. And of course, we have our coaches to be very grateful to us as well. They have been with us throughout this journey, and they've been so supportive till now. And also, we'd like to thank everyone who have been so supportive of us till now. Thank you.
Thank you very much. Thank you. And I would like to invite the team of the Auckland University of Technology from New Zealand.
Tēnā koutou katoa. Tuatahi e mihi ana ki ngā kaiwhakawā mō tō koutou wā, tō koutou mātauranga, me tō koutou mahinui I tēnei whakataitai. Firstly, thank you to the judges for your time, expertise, excuse me, and service to this competition. Nā mihi hoki ki te COREX Foundation, mō tō koutou manaakitanga me te whakarite, I tēnei kaupapa whakahirahira. Thank you also to the COREX Foundation for your hospitality and for organising this remarkable event. Kina kapa katoa I whai wāhi mai ki tēnei whakataitai tēnā koutou. He honore nui ki te whakataitai ki tō koutou taha. To all the teams who participated in this competition, thank you. It has been an absolute honour to compete alongside each of you. Nā mihi nui ki te wānanga aronui o Tāmaki Makaurau, ki Nicolasa me te Embassy o Aotearoa ki te Hague, me te South Auckland Law Students Association, mō tō koutou tautoko. Our sincere thanks go to Auckland University of Technology, its staff, its lecturers, to the Nicholas and the New Zealand Embassy here in the Hague, and the South Auckland Law Students Association for their support. Ki o maua whānau me o maua hoa, tēnā koutou mō tō koutou aroha me tō koutou tautoko. To our family and friends, thank you for your love and for your encouragement. Ki nā kai tautoko kei te mātakitaki mai I Aotearoa I te toru karaka I te ata me taku tuahine ahi te reira, tēnei te mihi nui kia koutou katoa. To those joining us right now from New Zealand at 3 o'clock in the morning, and to my sister who lives in Brisbane, Australia, thank you for your support from afar. Nō reira, tēnā koutou, tēnā rā tātou katoa, kia ora. Thank you.
Hello everyone again, my name is Jazz. I'd just first like to thank you judges for taking out the time to be here, and without you guys this competition is not possible. So big gratitude there, and for all the judges that have been throughout the entire competition and served in previous years. I'd like to shout out to my family, Ria, Arzu, Mum, and Emily. I hope you guys are doing good at home. We'll be back soon. Enjoying my time in The Hague though. Advice to future teams in 2027, I would suggest have a team that you really gel with. Chemistry is everything in this competition, and you need to be together in your highs, together in your lows, and really just there for each other, and support each other in those tough times when you're learning something very new, something very difficult and very global. So that would be my advice.
Thank you.
Thank you very much. Once again, a big shout out to the teams, to our 4 finalist teams, and to all 32 teams that have been the part of this edition. And as already was said very correctly by the teams, it wouldn't be possible without our judges. It's you that make the competition possible just as much as students that prepare and research and argue. It's you that make their growth possible. It's you that encourage them through your scorecards that you send, through the notes that you advise them, that they, I'm certain, you might have already seen them implement in today's debates and in the debates before. So thank you sincerely. And if I just may, a humongous shout out to Professor Lorange for making this competition what it is. It's been a pleasure to have him as a colleague for the COREX Foundation. And not to get too emotional, I invite the judges to share the results of today's final. And how do I get that? Do you want me to hold it? Or you want me to hold it? We have to
stand here for them online also to see what's going on.
Yeah.
Um, I think we should do it. And then we can talk.
Okay.
Yeah.
All right. So for third place, I would like to award the University of Bologna.
Wonderful job. Congratulations. Thank you so much. Should I take a photo?
Eso. Forza Bologna. Forza Bologna.
Thank you so much. Thank you for the gesture.
Thank you.
Congratulations. On behalf of the jury, we would also like to acknowledge the great other team that has participated and is acknowledged. The University of Nairobi, Kenya, will be acknowledged with a tile that will be shipped to you, to Paul, Ian, and Jane. Congratulations on a great job. Well done.
Hello, everyone. And now we're going to announce the best oralist of the season. And this year I actually want to congratulate all the participants also present in here, but also those that are not at the final but had done an excellent job. And also congratulations for the Corks Foundation for getting together so many talented people. So now announcing the best oralist of the season. This trophy goes to Miss Yuden Dema from University of Bhutan. Congratulations, you're gonna receive it. But we also want to make sure that another participant that have been an excellent oralist would also be recognized for that. So for that reason, we have a specific certificate for Mr. Alessandro Roberto. Congratulations. Thank you so much. Yeah.
Well done. Well done to the best speakers. Well done, Ms. Dima, as well. Your certificate and trophy will come through the post. Congratulations.
And now, please join us to congratulate the team who secured the first place in this amazing competition. You are waiting? Okay. Auckland University. Congratulations. Congratulations. Thank you so much. Thank you so much. Thank you. Yes. Come on. Here.
I'm not sure what they are. Yeah,
It's
two of them in the
just-
team. Congratulations to them.
Thank you so much.
It was a
Can
big
stand here?
hike.
Stand here for photo.
No one wants to hold it.
As well.
It was too high. Too
Now, good afternoon. Congratulations. Personally, for me, it was a nail biter. I was amazed with the exuberance that both of the teams showed. And we would like to now offer the second prize, of course, to the University of Wangchuck in Bhutan. Congratulations to you. This is your trophy that will be shipped along with the tile that my colleague Michaela is showing.
Excellent work. Well done. Thank you.
Great job, guys. I don't know. There's a picture moment with them.
Here? To make this big?
Can we ask, right, students, please stay on camera. Yes.
Yes.
Maybe the best speaker for you as well. Can also hold on.
Where is it?
Where's the trophy?
Where's the best speaker?
Yeah. Oh, here it is. Yeah.
And if you move to on this side, then this camera can also catch them.
Yeah.
So they can ask.
Thank you.
Thank you, everyone. This marks another end of the tournament, of the Hague University Law Debate Tournament of 2026. It's been a pleasure to have you since 2015. We hope to keep you active or supportive of the competitions for the years to come and of the students. Honestly, I can't wait to see where you go in your next steps. So, see you in 2027.
Yes, thank you very much.
Before you leave the stage, Aurelie and Anna Maria, thanks so much for all the hard work you've put in. We owe you a big round of applause.
Thank you. Now everybody comes for photo. Hey. And thank you online as well. And kia ora.